Good morning in DC and good evening in Jakarta. This is David Merrill, the president of the US-Indonesia Society, USINDO. Today we have a terrific program on the trade agreement between Indonesia and the United States and associated trade factors. This is part of our USINDO Open Forum series, which is intended to give our USINDO audience and guests a deeper understanding of US-Indonesia developments than is possible from the headlines. It's managed by our new USINDO Vice President, Chris Wyrod, who's on the call. Today's open forum is to help us understand the rapidly changing developments in the US-Indonesia trade relationship. Last April, President Trump announced a broad set of so-called Liberation Day import duties, including a 32% tariff on Indonesia. The US and Indonesia informally agreed on a new trade framework first in July 2025, and this became specified in the US-Indonesia Agreement on Reciprocal Trade, called the ART, Agreement on Reciprocal Trade, signed in Washington February 19th between the two presidents. The ART eliminates tariffs on US goods, reduces tariffs on Indonesian goods to 19%, I believe, reduces non-tariff barriers such as local content requirements and administrative barriers, eliminates tariffs on over 1,800 Indonesian commodities, removes some import restrictions, and includes commitments to purchase billions of dollars worth of US energy, agriculture, and aircraft, and others. Food also. The next day, amazingly for its timing, the Supreme Court overruled the administration's justification for imposing tariffs in general. In response, President Trump imposed a blanket 10% tariff, quickly raised to 15% on all countries, including Indonesia. And then recently, maybe a week ago, the US also announced an investigation under Section 301 of the Trade Act of 1974 into alleged unfair trade practices by 16 countries, including Indonesia. This is apparently done to counterbalance tariffs that were overturned by the Supreme Court decision, but our experts will explain that. An Indonesian government spokesperson replied that Indonesia considers the agreement on reciprocal trade signed in February of this year to remain the main framework guiding bilateral trade relations between the two countries. So this deal is clearly important and historic, but the current tangled situation clearly calls for deeper public understanding, including views on the current situation for both countries, how each country perceives its trade, tariff, and investment strategy from this point. And to help unpack this, we are fortunate to have an excellent panel to inform us on these issues and take our questions. I'm going to start, well, let me mention who we have, and then we'll start. Bill Reinsch, Senior Advisor, Distinguished Trade Expert, and Scholl Chair at the Center for Strategic and International Studies, CSIS, in Washington, will share insights on trade developments and analyze the broader implications of trade relations between the two countries. Thank you, Bill. Ambassador Brian McFeeters, my colleague in the Foreign Service and elsewhere, Interim President and CEO of the U.S. ASEAN Business Council, will share perspectives from the U.S. business partners operating in Indonesia on the fluctuating trade relations and the impact of non-tariff barriers to trade. Another good friend, Dr. Eddie Pambudi, Deputy Minister for Coordinating International Cooperation at the Indonesian Coordinating Ministry for Economic Affairs, that's Pak Herlanga's ministry, and senior member of the Government of Indonesia's trade negotiating team. He came to Washington multiple times in the last year. We'll discuss the Indonesian government's negotiation of the ART and the current trade dynamics with the United States. Edmund Sim, partner and trade expert at the law firm Appleton Luff in Singapore and in Washington and maybe elsewhere, uh, real trade expert Broadgage, will review recent developments, including the legal framework for the ART, the impact of the Supreme Court decision, and mention the remaining legal international trade and tariff options potentially available. Following that, we will take questions from the online audience. Bill Reinsch, I invite you to speak first for perhaps 15 minutes or less. Bill.
Well, thank you. I hope it'll be less. It's good to be with all of you. There's a lot going on, and it changes virtually every day. So I'm going to talk about what's happened and what I think is going to happen on the tariff front and on the refund issue, which is going to increasingly be a subject of debate here in Washington. And then we'll get, I think, reactions from the other parties who are better informed than I am on what's going on in Indonesia. The decision that Ambassador Merrill referred to I think, is one that will have significant, long-standing implications for the relationship between our Congress and our president, because it really redefined that relationship in some important ways. It will not, however, have that big of an impact on the economics of the tariffs that we're experiencing right now because of the administration's intent to replace them via different statutes. The decision, which the opinion was 170 pages and had separate opinions from 7 of the 9 justices. But when you get through all the rhetoric, it was relatively simple. They had different reasoning, but 6 of them concluded the same thing, which is that the law in question, the International Emergency Economic Powers Act, does not permit tariffs, period. And so that invalidated the tariffs that had been paid. And it reaffirmed very clearly the justice's view that the American Constitution gives our Congress the power to tax, tariffs or taxes, and it really struck a blow to the president's assertion of the power to do pretty much whatever he wanted in the economic sphere. Immediately afterwards, same day, the administration announced that it intends to use other statutes to reimpose the tariffs that had just been invalidated. And I think it'll end up being at the same level, although there'll be a lot of debate about that. Their short-term action, which the ambassador mentioned, has been to impose tariffs under a different section of law, 10%. They're supposed to go to 15%. I don't think they have yet, believe it or not. I think they're still 10. I think there's a reason for that, which we can get into, but it's kind of peripheral to the main topic today, so I'll save it for later. That's temporary. Under the law, it can only be imposed for 150 days, and so we're operating under that right now. But the authority to do that is pretty clear. There are already 2 lawsuits against it. This is America. Anybody can sue anybody for anything, and they do. So we'll see how those go. But I think those lawsuits are not likely to prevail, even though the earlier one did. What the administration intends to do is to reimpose the tariffs under a different authority, which Ambassador Merrill mentioned, which is Section 301 of the Trade Act of 1974. That authorizes the president to take action against unreasonable or discriminatory practices that burden or restrict U.S. commerce. And the administration has announced multiple investigations into precisely that point. 15 countries, including Indonesia, on overcapacity as an unfair discriminatory practice. And subsequently, they announced 60 more investigations. That's 60 different countries investigating into forced labor practices. That also includes Indonesia on that list, along with 59 other countries. The law permits 1 year for these investigations. I believe the administration intends to complete all of them by July 24th, which is when the 150 days expire. That will allow them to avoid having to go to Congress and asking Congress to extend the 10% tariff. That would be I don't think they would win that vote. And so I think they want to wrap the investigations up before then and put these things in law. There are procedural requirements that actually have already been announced. There's already been an announcement, request for public, so who wants to comment can submit those comments. And there are going to be public hearings, I believe, in May on the various investigations. So anybody that wants to testify will have an opportunity to do that. My belief is that most, if not all, of these investigations are going to find the other country guilty of either overcapacity or forced labor or both. And that the remedy, I think, is going to be simply reinstatement of the trade agreement, the ART, Reciprocal Trade Agreement, that has already been negotiated. In Indonesia, that would be a 19% tariff, along with all the other commitments that were made on both sides in these negotiations. The administration has said from the beginning of after the court decision that it believes those agreements remain in effect anyway, regardless of the court's decision. But the reality is there's currently no legal basis for a tariff greater than 10%. The Section 301 investigations, if concluded and if a remedy is imposed, they would provide a legal basis. So I think what the administration is trying to do here is to recreate what is already negotiated. And in the Indonesian case, that will mean they will find the Indonesians guilty of these practices, and the remedy will be the trade agreement that has already been negotiated. Now, that will probably produce more lawsuits, and the most obvious one being different countries have had different tariffs reached in these agreements, 18, 19, 20, 15, in some cases 21 or more, it varies. It's the administration, if it wants to reimpose all the agreements, is going to have to explain why overcapacity in Indonesia justifies a 19% tariff, while the same thing in Malaysia justifies an 18% tariff, and the same thing in Vietnam justifies, I think, a 20% tariff. That will be the basis for the lawsuit. I don't think people will prevail in the lawsuits, but what I've been saying for months is the only people that really make a lot of money in this whole episode are the lawyers, and I think that's going to continue to be true. At the same time, there's a sidebar, there's a sideshow going on here. There is another statute, Section 232, that permits tariffs to be imposed in response to national security threats. And we've seen those already on steel and aluminum and kitchen cabinets, among other things. And there's a number of those that are already underway and were underway before the court's decision. And I think there will probably be some new ones. Those are not country specific, they're product specific. And so the remedies that are imposed will apply to many countries, not all of them. Not everybody makes steel, for example, but they would apply to, most, if not all, the countries that produce the various products that are under consideration. So expect more of those too, but that's not the main weapon. The main weapon is 301 because that allows the administration to duplicate what it's already done. As I said, there will be more lawsuits. There's already two on the 10% tariffs. There'll be more on the 301 tariffs. I don't think they're going to prevail. That brings me to the final issue is the refund question, which I think some of you probably have an interest in. The invalidation of the IEEPA tariffs means that everybody who paid them is supposed to get their money back with interest. That process is still being worked out. It appears so far that the Customs Service, which is the agency that collected the money, and the court, which is charged with administering this process, are really committed to play it fair and to do it fairly quickly. That is not true of everybody in the administration. And there are some people in the administration that clearly want to slow this down and make it as complicated for importers as possible. The judge doesn't seem disposed to let them do that, but that hasn't tested yet. And so we'll see how this plays out. In the short run, Customs and Border Protection, the CBP, the service that collects the money, has said that it will develop a computerized system for handling the refunds electronically in 45 days, which would be April 20th if you count weekends, a little bit later if you don't. And there are two hurdles that importers will have to get over. First of all, to clarify, the people that get their money back are the people that paid the money in the first place. So it's the importer, and I'll deal with what happens after they get the money in a minute. The importers face two hurdles. One, the government is going to make them apply for the refund. And that means they're going to have to submit the data on what they paid and what the item was that they paid it on and when they paid it. That's a little bit unfortunate because customs already has all that data. It came in when the duty was paid. But they're going to make companies do it again. I think probably because they're hoping some companies will forget to do that. And the government will then save some money and not have to refund it because I think the deal will be if you don't ask, you're not going to get. So the first thing for importers to do is get your paperwork in order and get it in. Some have already done that. In fact, some did that before the court decision, anticipating the decision. So if importers haven't done it, they should. The second thing the second hurdle is that the Customs Service decided, separate from all of this, to go entirely electronic, which they began on February 5th. So all these refunds are going to be electronic only. No cash, no checks, only electronic transfer. And in order to obtain an electronic transfer, you have to sign up. You have to register with Customs and Border Protection. That's not a complicated procedure, and it's not a very high bar, but you have to do it. And if you don't do it, you're not going to get any money back because the only way the Customs Service is going to refund the money is by electronic transfer. So if you're in that business, you need to go ahead and sign up. And you need to do that anyway, because this is going to be true for all refunds of even normal refunds going forward. The Customs Service is transitioning to an all electronic system. So you need to do it sooner or later, and sooner would be better. Now, finally, the way the U.S. law works, as I said, the person who paid the tariffs, the importer, is the one who gets the money back. Whether he keeps it for himself or whether he passes it back to the foreign manufacturer or he gives it, if he's a retailer in particularly, if he gives it to consumers in the form of refunds on what they bought or in the form of lower prices on future purchases, that's up to his judgment. The United States government is not likely to say anything about that. There is a bill in Congress that would require the refunds to be passed on to consumers. I don't think that's going to pass. And if it did, it would create an enormous administrative complexity of trying to figure out who bought this stuff and how much money to give them. So in the short run, the answer is that the importer gets the money back. What he does with it is his business. And it will be a discussion between him and the manufacturer whose item he imported and or the retailers to whom he sold it later. And with that, I'll stop. Thank you.
Well, thank you, Bill. This is a terrific overview and foundation for us. I'm now going to invite Brian McFeeters, President and CEO of the U.S. ASEAN Business Council, who has perspectives particularly on the views of his members who operate in Indonesia or anything else you'd like to speak about, Brian, please.
Thank you, Ambassador Merrill and USINDO for setting this up, and Undersecretary Reich, thank you for your comments. Dr. Eddy, good to see you again after 1 month. We had a very intense program here in Washington, D.C. And Attorney Sim, I look forward to hearing from you as well. What I'm going to try to do in a few minutes is maybe, put a little bit of a narrower perspective that basically says, what if the agreement on reciprocal trade between the U.S. and Indonesia is implemented? Now, there's so much uncertainty swirling out there, as Ambassador Merrill and Undersecretary Reich already posited. But I'm just saying, let's consider, as Ambassador Merrill said, the government of Indonesia is saying that they're going to stick to this framework, and we'll hear from Dr. Eddy Pambudi on that. And the USG says it's also going to remain in effect. So those two pressure points make me think that it's possible. So from the U.S. ASEAN Business Council point of view, a trade association that represents over 180 companies, half of whom, roughly speaking, do business in Indonesia, And by the way, a few of them are on the call, so they can, correct me if they disagree with what I'm about to say. But from the point of view of the US ASEAN Business Council, I would say, a simple tagline up front. We like the ART because it tackles NTBs, right? We really don't want to spend a lot of time on 19% versus 15% versus 10%. We want to focus on non-tariff barriers. So let me just spend a few minutes on that. I mean, it might be a little bit weedy, but I mean, we live in the weeds because non-tariff barriers are, they're things that snag companies and make it difficult to do business. So what I'm going to do is say what, in an ideal world, what do we want to do? U.S. ASEAN Business Council, our contribution, and how would we do it? And so the what, let me just jump right into that. The what is we want to work on areas that are in the agreement on reciprocal trade and make progress on them. And the number one for almost any U.S. company would be local content requirement. If you've spent any time on the Indonesian economy and U.S. business there, you'll hear people, everybody has, not everybody, but many companies have issues around local content requirement, which in essence says, if you're going to sell a product in Indonesia, you have to prove that you're making a majority, 40, 50, sometimes higher percentage of it in Indonesia. And it's very, with apologies to Dr. Eddie Pambudi, I would say the problem is not only those requirements, which is hard to pull off, but the complexity of it. There's a regulation that came out, I think, a few months ago that is 28 pages long about like, how do you do this? So that's intimidating, right? It's intimidating and it's difficult. So the agreement on reciprocal trade says, I'm just reading from Article 2.2, Indonesia shall exempt U.S. companies and U.S. goods from local content requirements. That's a very short sentence without any subordinate clauses. It's very clear. We don't have any naivete to think like, okay, it's done, like we could go on to the next thing. That's very much, in our view, the beginning of a process or the continuation of a process that's been underway where U.S. associations like USABC and U.S. companies try to make progress on local content requirements. In the U.S. ASEAN Business Council perspective, we've been working on this for many years. In 2022, we did a paper in connection, working with our companies that basically said, local content requirement, understand the intent, which is build up the industry of Indonesia. Every country should have the right and the ability to do that. But respectfully, in our view, local content requirement ends up maybe not creating the progress that the government of Indonesia is targeting. And also, ends up ironically raising costs in terms of if you go about the process of doing something locally the way that LCR requires, you will end up with higher cost goods. So it's not the best way to go about it. We have just this year, we had a consultation with the government of Indonesia, which has been very engaged on this. And we put together something like a 30-page paper that says this is what USABC companies care about in terms of local content requirement. So that's just suffice to say, like, we've gone deep on this, but we're very optimistic about having a more structured approach to local content requirement because of the ART. Let me just mention two other areas, and I won't go into as much detail on either one, but another one would be halal. Halal rules are another snag that really makes things difficult for U.S. companies. And again, I'll read from the Agreement on Reciprocal Trade, Article 2.9, quote, with the goal of facilitating U.S. exports of cosmetics, medical devices, and other manufactured goods for which halal certification may currently be required, Indonesia shall exempt U.S. products from any halal certification and halal labeling requirements. Again, a very clear statement. It's not self-executing. Indonesia has a lot of work to do. U.S. companies want to be part of that in a very consultative way. The third one I will mention, and there's others, but the third one I would mention would be import licensing for food and agricultural products. The agreement, Article 210, says Indonesia shall exempt food and agricultural products originating from the United States from Indonesia's commodity balance policy. And then it goes on to say more, which I don't need to read. But basically, it's a very, another very clear statement that says these kind of import restrictions shall not apply to U.S. agricultural products. I have some experience for that one. It's much more, in my view, much more complicated than it needs to be. U.S. exporters of fruits that are not even grown in Indonesia still face obstacles getting things in. So my point would be there's some articles in the press that say, oh, the U.S. won and Indonesia lost because there's so many requirements on Indonesia. I would say reframe it and think about consumers in Indonesia. having high quality U.S. products get into Indonesia is good. It's a win-win. Um, Let me just compare it to the way, like you also have to say compared to what? In my government experience, serving in Indonesia 3 times and elsewhere in Southeast Asia, the way that we did go about it back in the day, in the absence of a free trade agreement or agreement on reciprocal trade, was we used something called the TIFA, the Trade Investment Framework Agreement, which was a laundry list of things, irritants on the part of U.S. companies that were reported to the U.S. Trade Representative, and then we would work on those every year. In my view, it wasn't a very effective mechanism. It was, to oversimplify, it was basically, let's talk about these issues, in March 2026, and then I'll see you again in March 2027, and we'll talk about the same issues. So we're looking for a way to make real progress on non-tariff barriers. But again, this is not so that U.S. companies can shove their goods down the throat of Indonesians. This is so Indonesians have a choice in what quality products they want to buy. With that, I'll turn it back over to you, Ambassador Merrill.
Thank you. Sounds very interesting, Brian. Dr. Eddy was one of the lead negotiators for Indonesia during the trade agreement. He's been to Washington innumerable times on that negotiation and other things that we're doing with him, including strategic trade management, which we work with him on, and which is part of the reciprocal trade agreement. Eddie, please share your thoughts on all this.
Thank you, Ambassador Merrill, and also thank you, Pak William, and also thank you, Ambassadors Brian, with your very beautiful remarks on this. Yes, I just also want to share in the two perspectives in the negotiation. One, of course, in the question of the agreement itself, but in the other perspective, I also want to discuss about why that we have to negotiate with the US in this case. Now in Indonesia, we have a two big queue or question. One is why then we have an investigation after the agreements. And so many counterparts now also question this. And the other thing is what the benefit of the ART from the 301. So let me a bit explain in the first question. And I think William already explained about this one. Yes, investigation I think is what the procedure that the US have to do before the implementation of the 301 tariff. We understand from the beginning in Indonesia already mitigate from the last years that there will be a decision from the Supreme Court for the the agreement of reciprocal tariff, especially in the tariff determination. But we listen carefully when the USTR Ambassador Jamieson Greer declare and explains in the New York, I think in around December, that the government of US under the President Trump administration actually already prepared the alternative if the Supreme Court will rule out or revoke the determination of reciprocal tariff, which is IEPA Act. So that's why then we still continue the negotiation, because the substance of the agreement itself, it is not just related with the reciprocal tariff, but actually if we last year's follow the process before the legislation trade, USTR already released the reports, the evaluation of the trade in estimates from the foreign trade barriers, including Indonesia. And Indonesia actually reported under 14 pages with many of barriers that Ambassador Brian's already explained. So that's why I think as strategic partners, especially in trade and investment, we have, of course, concerns with the US exporters and businesses when they deal with the Indonesian regulation, because they face a lot of difficulties. I think with or without the agreement, we also need to concern and consider how then we have to make simplicity in our in our regulation, especially in trade and investment. So that's why we start from this, and then we discuss a lot the substance inside of the agreements that we finally also understand it's not only for the US businesses that Indonesia also need to simplify the bureaucracy system also for other countries. So we use this momentum also how to maintain the relationship. Even under the T5 1996, we don't have any councils to discuss what happened inside of the trade and investment. So I think this is the big who works as a strategic partners for Indonesia. Then US need to have a good forum, a good discussion to share something if they face the difficulties. So I think in the last month's event business summit, this is a good landmark and also milestone between Indonesia and the US start talking in business to business. So then it's not necessary to bring everything into government side. So they can also handle a kind of issues together, and also then at the end, government to government can discuss. The second perspective is about what the benefit actually of the ART from the 301. So after back from the US, means that after the signing of the agreements, we send letters to the USTR, also question about what the next step after the SCOTUS decision. So what actually the level of tariff from Indonesia? Because if I can share here, after signing between two leaders, Indonesia actually is already granted 18%, not only 19%. So I mean, this is also goodwill from President Trump to my presidents, also reduce even 1% less, but it also matters for Indonesia that just demonstrate that the agreement is also made in the goodwill from both sides. So even right now, the tariff is 10%, but if we back to the previous legal basis, Indonesia is already an 18 rather than 19. So it's good achievement as well. So we also anticipate by questions. So what next if Indonesia step into in the process of ratification into the parliament? Because we understand part of the agreement, if we move forwards into in the parliaments, they will questions the basis, the legal basis of IEPA already revoked by the SCOTUS. So that's why it means that totally the agreement is not applicable yet, because there's still part of the agreement still under the previous legal basis. So mean that we need to have another legal basis, which is 301s proposed by the USTR. Of course, the procedure that they have to run the investigation. And I think it's normal that it's not only Indonesia shall be investigated by the USTR. So that's why now the government is already prepared to respond to the investigation. We believe in our production there's no issues in overcapacity, because our manufacturers always produce based on customer demands. So there's no any other intention to oversupplying other countries or other economy or markets by our product. But we produce any kind of product we export based on the customer demands. And of course, we always try to comply with the international rule, such as WTO and other international rule by the industries. So we believe that our manufacturers already comply on this, and we also stand ready to prove this mechanism. In terms of the labor force, we already have regulation that we have to comply with the WTO. But now we're also working for the prohibition of the importation related with the forced labors. We just have a ministerial meeting last week, also together with Ministry of Employment and all associations that we consent to prepare the investigation argumentation from Indonesian side. Another perspective in this agreement, and last two round of the negotiation, if I can say this is not negotiation, but just discussion, because USTR also demonstrated flexibility to Indonesia and to discuss, and they listen carefully what the Indonesia explains, which one that maybe Indonesia face difficulties. So that's why under the agreement, we place a lot of in accordance of domestic law, because US actually is just proposed that the practices of regulation still consistent, transparent, and also predictable. This is exactly the same from the USTR report last year that Indonesia need to simplify the bureaucratic system in terms of trade and investment. So then many of businesses, exporters also can get equal position and opportunity to Indonesia compared with other countries. So that's why I think maintaining our strategic partners in this case, among other partners, is quite important. US is the largest, one of the largest market for Indonesia, and we already receive surplus on trade. But of course, now we have to simplify the regulations so that we can get the win-win from the trade relationship and investment relationship. So at the end, the agreements we expect can give benefits not only for the businesses, but also for the job creation for Indonesian people, but also from the US side also get benefit from this. We understand still a lot of issues that we have to make clear, especially in the implementation that Ambassador Brian just mentioned about the local content requirements. I think we have to maybe find the way the local content requirements, not just based on the cost, but how then we can set up the new regime of the local content requirement based on the opportunity by incentivizing industries that they can also part of the buffer in the industries. And the halal certification, I think we need to have the clarity how to implement this, because of course that this not make the confusion, because inside of this halal certification, two parts. One, of course, this and the principle is based on the Islamic law, but and the other thing is about the administration and bureaucratic. So hope that we can also work together. So then we can simplify the process of administration, so that halal certification is not part of the barrier. We can also facilitate exporters and also businesses from the US. Licensing, yes. We also want to simplify because it's not only the US face these difficulties. We also learned from the International Trade Barriers Index that Indonesia in the lowest rank. It means that it's a lot of homework that Indonesia need to fix under the deregulation program. Last, I think if Ambassador Brian mentioned about TIFA 1996, means quite long ago, 30 years ago. They already committed that we will have the Council of Trade and Investment, but until now we don't have. So hope that last month's business summit, again, this is initiated how then Indonesia and United States business can talk to each other and then also share what initiative, creative way or solution for any kind of the difficulties they face. So I'll stop here and back to you, Ambassador Mario.
Thank you so much, Dr. Eddie. And I just want to say that it may be obvious, but it's worth mentioning that for this to succeed for both countries, it's imperative that Indonesia have qualified professional experts on its side, such as Dr. Eddie Pambudi. And the more that both sides can have qualified experts, the quicker we'll resolve this. I now would like to ask us to hear from Edmund Sim, partner and trade expert at the law firm Appleton Luff. It's an international law firm. He's expert in trade. He's going to review the recent developments, the legal framework for the ART, the Supreme Court decision, and what's ahead, and put this whole conversation into context for us. Thank you so much.
Thank you, Ambassador, and thank you to the Society for inviting me. I want to look at this from a very broad point of view. So we're going to go back, you just mentioned 30 years ago. So 36 years ago, I was a law student at the University of Michigan, and my law professor was John Jackson, who those of you who study trade have seen all of his books. And he was the former general counsel of USTR during the drafting of the Trade Act of 1974. And so during the lecture, he was talking about various ways that the law could be used. Said like, well, there were some people, who wanted to use the law in various ways that, were, in his view, antithetical to his view of free trade. And he said it was particularly coming from a group of people tied to a guy called Bob Lighthizer. So, okay, so I took the information in the lecture. And so in the final examination, which is what we call in law school, like a spot the issue thing, where you get 10 pages single space of a fact pattern, and you have to write in an hour how many different laws you could invoke to deal with the trade problem. So remembering what he had said about Lighthizer, I wrote that you could deal with it by imposing a blanket tariff under the International Economic Emergency Powers Act. You could apply Section 122, which deals with balance of payments, which is now happening. You could use Section 301, which is investigation of trade and investment barriers. You could use Section 201, which is safeguards. You could use anti-dumping, countervailing duty, which we'll not talk about today. And you could also use something called Section 338, which is a law that dates back to the Harding administration. So it's over 100 years old. And I bring all this up by saying, like, these are all, the laws we're talking about here, some of them date back 100 years. So at the end of the examination, I got back and he gave me an A+. So little did I know, 35 years later, we actually are dealing with the consequences of this because, one of the main acolytes of Bob Lighthizer, the former USTR in the first Trump administration, is Jameson Greer. So everything you're seeing here is based on the thoughts of that group of trade experts dating back to the 1970s. They were just looking for a client who to enact them. And that is what has happened. So the IEPA, why IEPA? IEPA was used because it was the quickest, fastest way to achieve Liberation Day. All the other statutes we've been talking about, or that Undersecretary Reich mentioned, those require fact-finding and investigation and some legal procedure. IEPA did not. So that's why they went for the quick and easily implementable action. Now, the issue has been, of course, as you've seen, they went to the Supreme Court. My old fraternity brother, Neil Katyal, was the lead counsel for the plaintiffs. He went to the Supreme Court and got this overturned. So I will tell you the very first thing that I was reassuring to those of us in trade bar was that the Trump administration actually agreed to implement the Supreme Court ruling. That was not necessarily a given. So anyway, he did that. So then now you have 122 immediately, which they were prepared to do. There is the question, 122, Section 122 of the Trade Act deals with balance of payments issues. There is an open question as to whether we have a balance of payments issue, but which is why some of the U.S. states have gone to court to try to block the implementation of 122. I think it's very difficult for a court to question, even on this issue, the factual issue, whether there's a balance of payments issue or not. I don't think a U.S. court is going to question the determination of the president. And also more importantly, given that the duties are only in effect for 150 days, or you get any effective relief, that's an open question. Now, as to whether the rate is 10 or 15, the rate is 10. The idea was they could have been adjusted to 15 because that's the maximum level allowed under the statute. The idea has been floating around that they were trying to adjust the rates for certain countries to 15, some to 10. I think given the amount of time we have left under the duties, this might not happen at all. So they might just keep it at 10 and focus on 301. So why do we have two different Section 301 investigations? So if you look at the context, they basically have broken it out into two parts. One is a very broad investigation on forced labor, prison labor issues. Now, they're not talking about the actual enactment of law, they're talking about implementation. And why did they do it that way? Because they wanted a broad context that they could use to support the 10% reciprocal tariff, formerly reciprocal tariff under the IEEPA. And so you needed a very broad issue that would affect the entire world. 60 countries is effectively the entire world. And so the only other issues you could do like that would be VAT, intellectual property, other things that are fundamentally affecting the whole world. But the issue with those is that one, or for example, currency. The issues with those topics are that currency is covered by other areas of US law. IP has been discussed in the past. And prison labor, forced labor is a relatively green field, but it's also in some ways more sympathetic. So to certain areas of the constituency in the United States, particularly the labor unions and such. So there is some sympathy to going after this issue. And you can see it both in existing laws and also in newer laws, such as the Uyghur Forced Labor Protection Act. So the issue of prison labor, forced labor is, broad enough and more sympathetic than some of these other issues. But again, the purpose was to get a baseline 10% that would apply to the entire world. The overcapacity issue is meant to tailor the ART commitments. So, they will be able, and I believe they're working on that, to try to tailor each country's commitments under ART to fit within the overcapacity issue, because the overcapacity is not necessarily a countrywide issue. It's a sector-specific issue and a countrywide issue. So those decisions are to be made under that part of the law will be used to support, basically replacement legal theory for to support domestically the ARTs. So there will be, opportunities for countries and companies and other interested parties to submit arguments and have a public hearing to contest this. Given that pretty much everyone, especially from the governments, the foreign governments, understands what the purpose of the 301 is, I don't know if most countries are going to actually participate in this process. You will probably see some companies, importers and such, try to submit documents and stuff in the legal arguments to USTR and participate in the hearing, but I think that's more for either setting up a potential lawsuit in the future or for political PR purposes, because I think we all know what the outcome is going to be. Now, the question is whether one could successfully sue the president and USTR for enactment of 301. There was a court case that came up at the Federal Circuit in September, which the Federal Circuit basically upheld most of the discretion of the USTR under 301. There are some theories out there that you could go to the Supreme Court, and that case, and so the plaintiffs in the case I mentioned from September have asked the Supreme Court to take the ruling and review it in the next term. But, that just happened 3 weeks ago. Will the Supreme Court take it up? I would say that if they take this up, then that would be a great, to everyone, that would be an indicator that they are willing to address this issue. I have my doubts of whether anyone in the court really wants to revisit the issue of tariffs again, given how fraught the decision was in terms of getting to a common reasoning, even though the outcome, there's a 6-3, but how did you get the 6? It's all over the map. So the final part on the laws is there is one more, the 100-year-old law called Section 338, which allows the president to impose reciprocal tariffs against discrimination on countries that engage in discrimination against U.S. goods. And the key to that one is that the maximum tariff that can be imposed is 50%. You still have legal protections and investigation that has to be done, but there's more discretion, possibly in a broader context than 301 or 232, the other section that was mentioned previously. The reason I bring this up is that up until now, in fact, yesterday, USTR Greer said that acknowledged that this was out there. But the key thing is that if you went down 338 and you applied that, that would pretty much be a tantamount to a U.S. withdrawal from MFN. And if the U.S. withdrew completely from MFN without the legal justification of national security duties or emergency powers or unfair trade, and simply just went to 338, the WTO would be in an even worse state. So I think what is always recognizing is that the U.S. government still views that there is a role for the WTO. Now, what that role is under this administration remains to be seen. It seems like basically, the U.S. is not part of the dispute resolution process. They want to use WTO to pursue certain agenda items, fortunately, and that's still better than having the U.S. completely withdraw from the WTO. As you've seen, the U.S. has withdrawn from other UN related economic institutions. So the final part I want to bring up, which again is especially with a foreign audience, it's always a concern like, well, why is it 18 here or 19 here? Why do we have skill tariffs? And if you step back, that's from because you are all on the receiving end of the process. But you have to step back and think about the collection end. What the reciprocal tariffs or all these tariffs basically are a form of sales tax. The United States is the only country, one of the few countries in the world that does not have a national sales tax or VAT or GST, whatever you want to call it. And the Republican Party and the administration in particular has been viewed, the Republican Party has viewed a national sales tax as a important long-term goal. It has never been able to pass that because the Democratic Party views that as a regressive tax. And Trump administration views VAT as a trade distortion because they view VAT as encouraging exports. And in some ways, depending on how you look at it, it does. So, but the important thing is that the revenue, the money generated by the reciprocal tariffs is basically resulted in a restructuring of the tax income in the United States away from income taxes to a sales tax-based system. It's still an income tax-based system, but there's less revenue coming from income taxes. That's what's being used to pay for the great big beautiful bill and tax reductions and things that are consistent with the Trump administration's priorities. So in other words, the money is there. And that money is always, given what the administration has wanted to do to support the duties in 301 or other measures, that's not going away. And one of the things in Washington that remains true is like, once you have something that brings in real money, people are very loath to disturb it. So, I tell foreign clients, this is not something that's going to go away in the midterm election or even in the presidential election in 2028. Regardless of who is the president or which party has control in Congress, the money's there. And so they'd be very loath to disturb that source, once it gets into place. And it's already into place. So the sum context of all of this is that regardless of the domestic law issues in the United States, the ARTs are in place and they are international agreements. Now, whether or not you want to exploit or use the weakness under domestic law of this is up to the foreign parties. But it's not, but you have to consider in terms of negotiating position and such, because, is it really wise to try to revisit issues that were resolved in the ART just because you view the United States as not being able to implement its commitments? The issue of domestic parties being unable to implement their commitments is not a new one. It happens in every country, and that's one of the issues we have here. So I can get into more details about how to get your money back if you're an import and all that. Undersecretary Reich has basically explained that. The basic thing is just sign up on the computer system with a CVP. Get your broker to keep track of it, and then make clear when you're going to get your money back. The one thing I would say is the procedures that are being talked about right now at the Court of International Trade are still subject to court appeal. So it is possible the U.S. administration will appeal that ruling, any rulings from the court, to a higher level, and we could be there for another year. However, the same court that's currently hearing the cases has estimated that every month that passes where this is not resolved is an additional $150 million of interest payments. So you add it up after 1 year, we're talking almost $2 billion. So is the administration, again, the administration is probably hoping that some people don't try to collect all the money, some not, we'll see. So anyway, I just wanted to give this a very broad and a very short-term context of what's going on, and be happy to take any questions. Thank you.
Thank you. Edmund, that's a great presentation. One thing that you've convinced me on is, despite all the uncertainties about these trade agreements, the one thing I can be certain about is that international law firms specializing in trade have a bright future. Let's go to the question and answer part. We have, I'm told, around 140, 150 people viewing this. Unfortunately, the technology doesn't permit them to speak live, but I'm calling on Chris Wyrod, our vice president, to select from the questions that I hope he is seeing and call on 4 or 5 or more people in the remaining time.
Thank you very much, Ambassador Merrill, and thanks all our panelists for your great insights. We currently have just one question, so I would request any of our online audience to please click on the Q&A button at the bottom and feel free to type in any question you'd like to share with our panelists. The first question that we have is from a current student, Indonesian student. His name is Denny Indra. His question is to Dr. Edi Pambudi. He'd like to know about Indonesia's approach to trade and investment control mechanisms on national security related grounds. He notes that the ART has Indonesia committing to establishing and applying a mechanism for reviewing inbound investments, while also cooperating with Washington on related investment issues. And he's interested to know from Dr. Edi the approach that Indonesia will take, whether Indonesia will have its own specific approach or draw on other approaches or models. He mentions CFIUS as a potential model, or a hybrid approach that Beijing has embraced. Dr. Edi, do you have anything you'd like to share in terms of, without giving away all your plans, but any thoughts about how Indonesia might approach this? Thank you.
Yes, thank you. Thank you. So actually in this discussion, we also have a various perspective in terms of this. And of course that in Indonesia is quite clear. We'll not try to restrict or even control any kind of investment, because we can engage with many countries. And as we also convey that Indonesia already have an agreement with other countries before we made an agreement with the US. But we also understand sometimes the issue about the national security and other things that related with the US interests. So that's why we are eager to talk in the many of mechanisms that we explore together. But in this case, that we try to simplify the mechanism, especially in the bureaucratic system first, because we understand that our system now is trying to fix the investment mechanism from the licensing regime into a risk-based regime for the investment. So we just also want to deregulate in this mechanism, but we are not in the intention to control any kind of investment. Even we also try to respect the U.S. interests in this. So that's why in discussion we try to make a layers of the mechanism that one of course that Indonesia need to get the request from the US if any kind of concern, and then we will identify the the requests. Then of course that we have to follow our national interest and also the domestic law. Then if it's necessary, then we will work together and sit together in terms of find the solution. And compared with another agreement, Indonesia and the US agreement and the RT, we already set the consultation mechanism in the Section 7. So that's why then the RT for us is very flexible. If any kind of amendments or changing or any other alteration inside of the agreement, that we can sit together and then we try to talk together. So until now, we don't have any specific model that we will try to implement, but we now also explore some of the ideas how we can manage together the investment.
Thank you, Pak. We have another question. The questions are rolling in, so thank you, everyone. Tyler Matos has a general question about an article of the trade deal that mentions technology and hardware for modular nuclear reactors for Indonesia. It's an open question if anyone wants to touch on this specific issue of sharing nuclear technology and nuclear reactors for any of the panelists. Any thoughts on that?
Let me have to answer this because
Please.
since 2023, we already signed the MOUs between Indonesia and the US. Now we also work together with some countries, including Japan's and the SMR. As you know, that the modular reactors now is becoming initiative in many countries because it's trying to make the nuclear reactor even more efficient by movables from others region. And as you know, in some of the region of Indonesia, we need to have a big load of the electricity coming from the specific resources. It's not just related in the fossil fuel like coal, but we also need to explore another resources to electrify the smelters. So when the smelters done that, they can move into another region. It's needed by another industry. So that's why we try to explore the SMR technology with US. Then we started the technical assessments since last 1.5 years and work together with our Research and Development Institute in Indonesia, and also already resulted the final reports. So then we also opened the opportunity from the US to the technology and set up the new the first SMR in Indonesia quite soon, especially in the specific location. This location is also very fit with industrials that needs the electricity from the SMR. So I think this is also an opportunity that we result from the agreements that we step into in the technology of the SMR.
Thank you very much, Pak Edi. Would any other panelists like to touch on this this issue? Hot button issue. Okay. If not, then we'll continue. The next question is for Undersecretary Wright. Let me just right here. Let me summarize it for you. The anonymous asker is interested to know about the legal framework. So they're asking what bill in Congress requires the importer to pay back the tariff? And then what is the repercussion and the impact on US business manufacturing goods in foreign countries or foreign businesses manufacturing outside of the US? This is again for the repayment of the tariff. Over to you, Bill.
Yeah, I haven't studied the details of the bill because I think the chances of it being enacted are very small. So I don't think it's going to happen. It's been proposed by a number of Democratic members of Congress who are in the minority, and so that's the main reason why I don't think it will move forward. I don't know if the bill goes beyond, Edmund may know this, whether it provides details about how it will be handled. My sense is that demanding or requiring that the refunds be passed on to the consumers would be an enormously complex administrative process. You'd have to track down things, who bought the items that were covered by the tariffs and, uh, contact them and figure out how to repay them the amount of the tariff in each case. If the customer, I mean, in some cases it's feasible. For example, if the end customer, if you've imported parts and components, auto parts would be a good example for ultimate inclusion in an automobile. There's the universe of people who buy those is limited. It's not like you go to Walmart and may have a big business. Well, actually, they probably do sell some. Home Depot probably does sell some auto parts, but for the most part, these are sales to, major automobile producers who have good records and keep track of all this stuff. You could probably do that administratively. On the other hand, if Walmart is required to refund the duties it paid on the many items it imports and then sells at retail, it'll be enormously complicated. I don't see it happening. And so I haven't really given a lot of thought to what the impact would be. I guess in theory, uh, it would be contribute to some further decline in inflation. But I mean, that's kind of an irrelevant conversation because right now the overall the macroeconomic data conditions are really being driven more by the war in Iran than they are by tariffs. And I mean, the tariffs end up being 166 billion, but that's, I think relatively small compared to the other things that are going on in the U.S. economy right now. I don't know. Edmund, help me out here. Do you know any more about
Yeah.
that proposal?
I think that's basically a political gesture ahead of the midterm election. There's no way to make that go through. And the other thing I think is that, there actually are law firms they have filed a class action lawsuit against Costco, trying to collect the money on behalf of the people who buy product from Costco and want the refunds back that Costco's claimed. I mean, to give you an idea, like you said, like all lawyers are making money off of this. Like one of the law firms that's actually involved in this type of litigation is a firm called Morgan and Morgan, which basically advertises for car accidents on the side of the highway. So, which is the last kind of law firm you'd expect to do this type of trade law. So, why? Because there's money involved. So when you have money, you have lawyers. So I think a lot of this is just show and people trying to make, their part of it. I mean, one of the things we did not talk about is there are actually financing firms which are running around the United States offering to buy up claims for unpaid duties or to get repaid duties and offering at like 50 to 60% discounts and like paying, in other words, they're buying out a small importer's claim for the IEPA refunds and giving them 50%, and then they're packaging them together into a bigger lawsuit. That's why you're having over 20 or 30,000 complainants trying to get money back. Some of them are big companies, some of them are basically people just on the street. So it will take time. I don't think this is the right mechanism. I think people are expecting this to be a mechanism or the class action suit. It's not going to happen. And in some ways, if you are truly in favor of free trade, making these kinds of arguments about passing through the consumer can be counterproductive. But again, the proponents of free trade are few and far between these days.
Thank you very much. Moving on to the next question. It's another question for Pak Eddie. It's specifically asking about financial restrictions on natural resource export earnings that are under the ART. And if there's a timeline for reviewing or rescinding those regulations on the natural resource export earning restrictions for you, Pak Eddie.
Thank you, Pak Chris. I just take a look many of question addressed to me. That's why
So many.
into this. But okay, so in this regards, in the process of discussion under the negotiation, we propose not directly remove the regulations, because of course we have also a strong argument that we have to implement this provision, especially in natural resources exports earnings, because we also need to maintain our foreign currency against US dollars and rupiah. And we also need to maintain our regime and managing the foreign exchange. So that's why we still need to keep the natural resources export earnings coming from Indonesia. But again, we propose to review within 12 months to find the way how then we can make together in this case, because US, especially from the Department of Treasury, also understand the purpose and the objective of Indonesia implement this regulation. But again, it is not right to restrict the process of having controls in natural resources export earnings for the specific company or US companies. But we give a room for Indonesians policymakers to formulate the best policy, and then also not try to make any kind of difficulties for the US exporters in Indonesia or US investors in Indonesia. So that's why we give a specific room to continue the discussion under the ART. Again, even USDA also mentioned that the FTA is practical document. We always try to find a way how to get the best implementation at the end.
Great, thank you, Pak Eddie. One other question for you from a few of our attendees, Pak Eddie, is about the parliamentary process for ratification. If you can give some insights into your understanding of how that will proceed or
Yes.
won't. And
Yes, but
go ahead.
so I'll try to emphasize, of course, that we want to continue the process of ratification in this. We have to make sure that the legal basis for the RT is fixed, because we understand part the agreements still refer to the previous act, which is IEPA is already revoked. So that's why, as a whole, that agreement cannot move further into the parliaments, because our parliament also will questions the legal basis of this. Even another part of the agreement still valid, because it's based on the negotiation and also based on another reference. But to make everything certain, so we will follow the process of investigation. I believe they will process this until June. So before the last due of the 122, section 122, then we can move into the certain legal basis. Then both sides can also process in the next step.
Great, thank you, sir. And if I can just add one more question for you, Pak Eddie, and then we'll try to find questions for others. There's another question regarding the exemptions that are noted under the ART. There's some 1,800 exemptions for Indonesian goods, and whether those exemptions will continue despite not being ratified yet, or if there's a way under section 122 that those exemptions can continue for Indonesian goods. Any insights into that, Pak Eddie?
Yeah, today I just received the emails to get invitations to discuss the amendment part of the ART, including the Schedule 2 is still referred to the executive order. So that's why we also fix this, because of course that we have to replace the inoperable on the legal basis from the previous IPA Act. But that's why that we will final rule we will discuss again. This, of course, that Indonesia expect the exemption is still fails for the agreement because it's also one of the benefits that Indonesia can receive to secure our market and also our laborers who works on these stuff.
Thank you, Pa. May I ask Mr. Sim if you have any perspective on the legal side of that, whether these exemptions under the ART still stand, or are there other legal mechanisms for them to be used? Go ahead.
Well, I mean, again, Section 301 is very flexible. So, in terms of U.S. domestic law, all the things could be done. So we just have to wait for the process to be completed. And I think that's the general idea of why they picked that, as opposed to other areas of the law. So, and again, the agreement, the ART still stands as a matter of international law, at least until someone decides not to denounce it and withdraw from it. So, but that's different from the idea of actual implementation. And I think ratification, the issues that Paketi is talking about, are very important because if they're not ratified, they can't be enforced. And my other day job is talking about the ASEAN Economic Community, and I'll tell you things like ATIGA and trading goods services. Implementation is the key issue in internal ASEAN agreements. So I think ratification is quite important. But again, an international level, these agreements stand.
Thank you very much. And then maybe for any panelists, but maybe Under Secretary Reinsch, this might be a question for you. It's open for anyone though. It's the question is comparing the ART to other agreements such as the Indonesia-EU trade agreement and RCEP. The attendee is interested to hear your comparative perspective of the ART and these other kind of agreements.
Well, I think I'll probably defer to the others on that. I think the view in the United States and probably the view in Indonesia, although Dr. Eddy has been tactful about this, is that the ART is not really a balanced agreement. It's one in which Indonesia made more concessions than the United States. RCEP and other bilateral or regional agreements that are either concluded or being negotiated tend to follow the more traditional pattern of focusing on mutual concessions and market access. One of the interesting things that we've noticed about what's going on is that basically the United States signal through the tariffs and the actions the president has taken is that the United States is no longer a reliable trading partner. And the obvious thing to do in that situation is find other partners, hedge your bets. And other countries are doing precisely that. Canada is negotiating with various ASEAN countries. You mentioned Indonesia. The EU has concluded Mercosur finally. It's concluded the deal with India, as has the UK. The line of countries wanting to join CPTPP is getting longer. All these things are going on with the United States on the sidelines. And the interesting thing about those things are, to my view, they're fairly traditional trade agreements. They're about market access. They're about opening markets in both directions. They're about producing win-win agreements, not win-lose agreements. So, to me, they're kind of a reaffirmation of the rules-based trading system and a good sign. The world is moving on in a positive direction. They're just doing it without the United States. Some of the agreements, RCEP being a good example, I think are fairly modest in terms of the obligations that are imposed on the parties. But even so, the important difference between those and the ARTs are that they're really reciprocal in the true sense of the word, in that both parties have made concessions or all the parties are making more or less equivalent concessions.
you. Any other panelists care to comment on comparing ART to other Indonesia agreements, EU, RCEP, or others?
I would say that because the ART expressly is the product of an interplay of asymmetrical power, that in some ways, in other words, the illusion of equality is not there, that it actually may be easier for the United States to get implementation of the ART. That's just it's, that's just a product of the times.
Thank you. We're running low on time, but I think we can probably take a few more questions. Is it okay, Ambassador Merrill?
One and two, sure. Then we
Okay.
should wrap up.
There are a couple of questions regarding ensuring fair trade practices and logistics. One is about, maybe this is to Pak Edi. The viewer is concerned that with zero tariffs on US goods that might increase counterfeiting or smuggling or bribery. If there's any actions that the Indonesian government is prepared to take to try and limit counterfeiting or smuggling practices if the ART goes into effect. And a similar related question a little bit is just on rule of origin. How does Indonesia view the language on rule of origin and alignment on its import restrictions? Maybe, Eddie, if you have some thoughts on those, appreciate it. Thank you.
Yes, thank you so much. So when we try to implement the lower tariff until 0% for most of the product from the US to Indonesia, actually they will help our industries also to get the raw materials. So because most of the products of the US product in Indonesia is part of the industries like soybeans, corns, and others. So that can also help for the food and beverages industries to result on other products. To mean that Indonesia still benefit from the value that the US supply many of commodities of Indonesia. And of course, for some of the commodities that previously is very expensive in Indonesia, like cheese and any kind of product from the US, automotive parts and others, that Indonesia also can benefit for the lower price. So hope that they can also help in terms of managing final product to Indonesia, make our industries more competitive. So we still believe that we can maintain the market from any kind of variations on this, because we give a room, and of course that we have to even we try to simplify the requirement, but we still straight in the process of monitoring the market. So it's still there. And another thing that we also need to prepare is how then we can make the process of like licensing even more smoothing, the process of the bureaucratic system. They will not only for this US, but also for other countries. So they will help our industries grow in Indonesia.
Thank you, Pak Edi. And a final couple of questions deal with the question of next steps. We talked a bit about this already, but maybe I'll ask Pak Edi for just your final remarks on this, what you understand as the next steps with trade negotiations, and then sort of long-term, are these going to be long-term developments in your opinion, or they might in a few years start at zero again and start from scratch with a new administration? Anyway, maybe the next steps we can start with. Over to you, Pak Edi.
Yes, I think I will use the very simple analogies. Suppose that Indonesia is store, then the US the buyers of the Indonesia's product, and one of the biggest buyers. Of course, that we also need good services for the buyers. We listen carefully what the buyers request to the stores. So that's why it's important also to maintain the relationship and trade and investment with the US as one of the very strategic partners to Indonesia. And of course, we still respect each other in terms of the law that we will implement. But at least after the almost 30 years since 1996 that we don't have any council to talk each other. So it's timely now to have a good rooms that business to business from Indonesia can talk and also can share how then we can share the benefit and find the win-win solution with this momentum. And I also want also mention one of the questions. So what the relationship with the POP is different. ART is already there before the POP, so that's why I think let's consider clearly about this one. So how then we can make the US and Indonesia as strategic partners in terms of trade and investment.
Thank you very much. It's a great summary, Pak Eddie. I'll hand back over to Ambassador Merrill. Thank you.
Thank you, Chris. Thank you, everyone. Thank you for educating us about the possible way forward in realizing the potential benefits from US-Indonesia trade and a better trade regime. This session has made a complex subject much more demystified for us and confident about the way forward and about the people that are handling this. I'm sure our audience joins me in thanking all our panelists for a great presentation. Thank you, and look forward to following this subject.